Hello everyone, welcome back to the Legal Explorer. Today I am discussing an important Supreme Court order about POSH Act, POSH Act, which is nothing but the Sexual Harassment of Women at Workplace Act 2013. The question was, should political parties come under this law? The Supreme Court has now answered to this question. The Supreme Court simply answered no. And this is what every law student and judiciary aspirant needs to know. Now we'll discuss the background of the case. See, the background of the case is a lawyer named Yogamaya MG, filed a petition. She wanted that women who work in political sector, for example, party workers, volunteers or office staff, to be protected under this POSH Act. She challenged a Kerala High Court judgment from March 2022 which had said that political parties are not workplaces under the Act. But what did the Kerala High Court said? See, the POSH Act applies where there is a clear employer and employee relationship. The political parties don't have that kind of formal relationships with their workers or volunteers. So they are not required to set up internal complaints committee, which is called as ICCS. So this was the background of the Kerala High Court, what it has given the judgment. See, what were the arguments of the Supreme Court? See, the lawyer argued that the POSH Act was made after the famous Vishaka versus State of Rajasthan case. It was meant to cover all kind of workplaces, even in informal sectors like film, media and politics. Words like workplace, employer and employee were kept broad on purpose. So excluding women in politics or in film association would defeat the objective of the act and also violates the Article 14, 15, 19, Clause 1, Subclause G and Article 21 of the Constitution. So these were the petition challenged and the lawyer argued. Now we'll discuss what was the decision of the Supreme Court and why did Supreme Court said no. See, the Supreme Court bench, who are the Supreme Court bench? Chief Justice B.R. Gavai and Justice K. Vinod Chandran and Atul S. Chandrukar refused to entertain the plea. The court asked, how can a political party be called a workplace when there is no employer and employee relationship? So the petition was dismissed. Now, earlier too, the Supreme Court had said the same. But see, if someone wants the political parties to create internal mechanism, the Election Commission of India is the right authority to approach. The court had already declined a similar public interest litigation, nothing but PIL. So the court had already declined a similar PIL last year. So now I am going to discuss what are the important points that judiciary students should focus on this Supreme Court judgment. See, POSH Act 2013, remember its purpose and scope. Definition of workplace wide, but the court still looked for organization, control or employment relationship. Article 14, 15, 19, Clause 1, Subclause G, Article 21. Often invoked in gender justice cases. See, what is the best remedy for political parties? The path is Election Commission guidelines, not a direct Supreme Court order. See, the one who are preparing for APP exam, Assistant Public Prosecutor exam for both Andhra and Telangana, as it is a criminal, POSH Act comes under criminal law. So this judgment is very important. Try to remember. So this judgment shows how the Supreme Court balances social protection laws and the limits of legislation. So for judiciary exam, you need to focus on Vishaka guidelines, the POSH Act definitions and the recent case laws like this one, whatever I have explained this. So this case law is very important. If you found this video helpful, don't forget to like, share and subscribe for more legal updates. You can share this video the one who are preparing for the APP exam. It will be helpful for the students. And we are going to start an APP batch from September 20. For more details, if you want to enroll into the class, you can WhatsApp us and you can directly call us on the below given number 95500100531.